sub C, that says, in addition to any examinations that the commission orders, Dr. Cornu-Labat is free to provide you with other examinations from other providers. And you are required to consider those other examinations when he provides them to you, but it does not excuse him from attending the examination that the commission orders. It is in addition to the examination the commission orders, not in place of it. He cannot comply with the order by getting his own examination from a provider he chooses. The evidence before you will be that the notice and procedure required by the statute was followed in this case. Dr. Cornu-Labat had the opportunity to be heard on his objections. The commission considered both sides' documentation and ordered the examination in this case. Dr. Cornu-Labat has not submitted to that examination. Also by statute, a licensee is deemed to have given consent to submit to this kind of an examination when the commission directs it. He has not done that. He is entitled to his concerns about whether this should be necessary. Those concerns have been heard, and the commission has ordered this examination, which is by local providers and which will be paid for by the state. So he is under there's no reason why he can't submit to this examination. He has simply chosen not to. And because he has done that, we ask that you find he has failed to comply with the lawful order of the commission and that you suspend his license until he complies.
Thank you, Ms. O'Neill. Dr. Cornu-Labat, did you want to make an opening statement?
Certainly.
Actually, I think what I'd like to do, sir, is I'm going to put you under oath now. I do that when people represent themselves, so that if they say anything during their opening statement that should be considered as evidence, that it can legally be considered as evidence by the members of the panel. So I'll ask you to raise your right hand, sir. Do you swear or affirm that the testimony that you shall give will be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you, sir. And now you may make your opening statement. Thank you.
Thank you. Your Honor, Commissioners, I appreciate the opportunity finally of being able to present myself to you and be able to present my arguments regarding an issue that has been ongoing for over 18 months and that has certainly had a tremendous impact on my life and that of my family. An example of that is the fact that I am not represented by an attorney today, because at this point I am essentially unable to afford an attorney. I will make sure I comply with the expectation that I know every angle of the administrative law and the proceedings, but certainly there will be some glitches. I am, after all, a lay person in terms of legal matters. What the Commission is today, or Mrs. O'Neill has argued today, that is the narrow scope of this hearing, has been delineated by the letter of the law. The argument I want to bring forward today relates essentially to the intent and purpose of the law. And in regards to the intent and purpose of the law that regulates the Department of Health, that regulates the Medical Quality Assurance Commission, and your function to the public, in regards to that intent and purpose, I have complied with the requirement for the sake of the public safety with ample margin of safety. And this is what my argument will be centered on today. In regards to the fact that I refused to comply with the so-called order that was issued on September 22nd, I will not deny that I refused to comply with something that in all its evidence lacked absolute seriousness, professionalism, and even was lacking aspects required by the law. and I intend to argue these with the presentation of witnesses, and although I have not brought any new evidence here, I have presented a tremendous amount of documentation to the Commission over the last 14 months in regards to everything that surrounded what brought me here. And this includes the issues that explained the reason why I was accused of being supposedly insane, what was done about those accusations, and what I brought forward when supposedly the Commission gave me a chance to present my side of the story. Aside that, for all intent and purpose, from every evidence that was presented afterwards, everything that I brought forth to question the intentions, the motivations, and to give the reasons why I had been accused in the first place, as far as I can tell, it was plainly ignored. To this point, the Commission has treated me with what I perceive as absolute disrespect and lack of consideration. And in every aspect of the procedures, I have received a clear evidence of lack of seriousness and professionalism. And it all ended up in the point where I am the one today being accused of unprofessional. The question is not my degree of professionalism or not. The question here is, have I respected the intent and purpose of the law in addressing a public concern, such as a practitioner that's possibly going bananas? And I intend to demonstrate today that I have fulfilled that intent and purpose with ample margin, and that my refusal has been to an imposition that was never justified clearly, was never backed by credible and reliable evidence. And in this procedure, the weakest link on the whole thing, which is me, has been the least considerable of all. That's, for now, all I have to say.
Thank you. Ms. O'Neill, did you wish to present any witnesses this morning?
I do. I call Wayne Carlson.
Mr. Carlson, ask you to raise your right hand. Do you swear or affirm that the testimony that you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Ms. O'Neill?
Would you state your full name and spell your last name for the record, please?
Wayne Carlson, C-A-R-L-S-O-N.
Mr. Carlson, where are you employed?
I'm employed by the Medical Commission, Department of Health.
And what is your function with them?
I'm an investigator.
Did you work on Dr. Cornu-Labat's case?
I did.
And have you checked the record for that case recently?
Yes.
Has Dr. Cornu-Labat submitted proof that he has complied by getting the examination that the commission ordered in this case?
No.
I have no further questions.
Thank you. Doctor, this is part of the proceeding where an attorney would get to cross-examine the witness. Now, cross-examination is limited to just what he testified to. Do you have questions regarding that?
Meaning I cannot ask any other questions?
Well, let's try it this way. Let's let you start asking questions. If you exceed the authority of cross-examination, I will stop.
Okay. Mr. Carson, you were the person in charge of the investigation of my case, correct?
That's correct.
during your investigation, did you ever, and I'm assuming the investigation of my case was not the first one.
That's correct.
Do you interview the people involved in the disputes? Is it a routine for you to do that?
In most cases, yes. It all depends on the case.
Right. Now, in my case, did you contact me at some point during the investigation?
Yes.
Other than through a written letter?
I don't recall. I believe I talked to you.
Well, at some point I
At some
called
point,
you.
yes.
Yes. But did you have in the process of your investigation, was it in your agenda to interview me?
No.
No. Did you interview, or was it in your agenda to interview the people in the hospital?
Some of them.
Okay. Once your investigation was completed, did this investigation generate an investigative report?
Yes.
Was this investigative report consisting on 2 pages?
I don't recall.
I believe, and again, we will run, I'm sorry, we will run with the limitation of the evidence that has been presented throughout the case versus the evidence that I am allowed to present today. Specifically, exhibit number 2 to the case that was brought in front of the commission, which is not the exhibit you have in your hands today. Consisted on a memo from Mr. Carlson.
Objection. I don't think that's a question. I'm not exactly sure what it is he's doing now.
Okay.
Yes, I can explain what I'm trying to do. It's as part of this proceeding, there was an initial phase which was discovery. Discovery consisted of presenting all the evidence in the file to be able to build up the case. As part of the discovery, there was none of the evidence that had been presented to throughout this case. Essentially, the entirety of the file was not presented in discovery. And specifically, what I'm referring to is that Exhibit 2, Exhibit 1 of the original file goes from that's stamped, page 1 through 3. Exhibit 2, that immediately follows in the file that was given to me in July of last year, starts in page 11 and corresponds to a memo that Mr. Carlson presented as part of, I'm assuming, his investigation. So the investigative report that should have been generated from his investigation, if that is the procedure, and this is what I was trying to point out, has been missing in the discovery and in the evidence from the side of the Department of Health.
Okay, let's try this.
I guess just quickly, there were no discovery motions. There was no argument about a lack of discovery up until this morning. While Mr. Scully was representing Dr. Cornu-Labat, there was no question about whether discovery had been complete. And I was not aware that there was any dispute as to the discovery in this case.
I'm going to ask that I have a request from one of the panel members. The panel has a question that they wish to submit to me. When I'm acting as their representative, they're allowed to talk to me outside the presence of all other parties. So what I'm going to do is I am going to ask everyone to please clear the courtroom, turn all of the cameras off, and I will come out and